The defense attorney called me and said, listen, this case is coming up for trial next month. Can you give me a demand so I can go back and talk to my principals and so we can start negotiating on this case? You know what I said to him and why it made a difference? Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I told this defense attorney I was not going to make a demand in this case. And now he was shocked. He couldn't understand it. He's like, what do you mean you're not going to negotiate? What do you mean you're not going to make a demand? If you're not going to make a demand, how can we go ahead and make an offer? How can we go ahead and understand where you want to be to try and resolve this case? I said, I'll tell you why. My client wants to go to trial. My client wants a jury to put a value on his injuries. We don't believe that there is any possible way that you and your principals will be able to come to a fair number of what we believe the injuries are worth. And as a result of that, we have no interest whatsoever in trying to negotiate this case prior to trial. Now, did that shut down the lines of communication? It didn't shut down the lines of communication, but it certainly shocked the heck out of it. Now, what do I mean? Typically, as a case is getting to trial, there are some instances where the opposing lawyer will call us up and say, hey, Gerry, listen, we'd like to start negotiating this case, but we can't negotiate just out of thin air. We don't know what it is that you're looking for, that you believe the damages and the injuries are worth in this case. So without having that information, we can't go back to decide how much money, if at all, to offer you and your client. So can you please give us a demand in this case? And now, once a demand is made, the defense attorney takes that amount back, discusses it with his principals, and then makes a determination as to whether they are interested in trying to negotiate. Our demand may be outrageous, and that may force the defense to turn around and say, listen, we have no interest in negotiating based upon that demand. Well, in that instance, you are going to trial, and a jury will reach a verdict in your case. What happens, though, if we make a demand that the defense believes may be within the realm of possibility? Are they going to give us the amount that we have demanded? In 99 times out of 100, the answer is no, which is why when an attorney gives a demand, it is typically an inflated demand, knowing full well that the defense is not going to come back and offer that amount of money. Instead, what they are going to do, if they are going to negotiate, is now they are going to come back and, depending upon their settlement strategy, is to lowball the offer or to make a serious offer, but significantly lower than what we anticipate or expect the real value of the case to be worth. So in that instance, now we get into a game of chess. And when I say a game of chess, it means now each side has to try and gauge and understand where the other side may be going. If I make a demand of, let's say, $10 million, and I believe the case is really worth $5 or $6 million, in all likelihood, the defense is going to understand that that initial demand that we make is not the number that I truly need to settle this case. Would it be great if they offered $10 million? Absolutely. Would it be overpaying? In this instance, in this hypothetical, the answer is yes. Would they do that? In all likelihood, they would not, at least not voluntarily. Now, if settlement discussions broke down, they said they're not negotiating with that demand, now we go to trial. Is it possible that a jury could come back with a $10 million verdict? The answer is yes, it is possible. And there are many steps that can occur in between then that will reduce that verdict, and the defense will surely take that on appeal. So now let's get back to the question I raised earlier. If we don't make a demand, is that going to shut things down? Is that going to change the tide? Will that improve our chances of ultimately trying to negotiate and settle this case? The answer is maybe, maybe, and maybe. The reality is we don't know until we have this discussion, until the defense attorney has had the discussion with his or her principals, and now they come back, and now we get a better insight by having an open line of communication who said, listen, we understand you don't want to make a demand. However, we think this case has a value of maybe $1 to $2 million. We'd be willing to start negotiating in that realm. Now, if your injuries are really worth $5 million, then that's not a discussion we want to have. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you're freezing cold like I am right now. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.